Well, thank you very much, John, for your service and for your thoughts and for, you just promised Paul Wright you do a lot of work, so. People that know Paul, watch out, he'll take you up on it, I know that he will. It's now my honor and pleasure to introduce Paul briefly. Paul, this is my second time tonight introducing a distinguished former prisoner. Paul was a Washington State prisoner from 1987 to 2003. And Paul is going to talk a little bit about the history of prison legal news. But the short version is that in 1990, while he was in the Washington State prison, along with, is it a couple of other prisoners? And started Prison Legal News, but Paul's really the one that's kept it going for all these years and has grown it from a few subscribers, I think I was one of the early ones, to many thousands of subscribers, international reputation, a website, a bookstore, all kinds of things. Many lawsuits. I don't know if people saw the list of lawsuits on the board today. I looked on the website today. There's a map on the Prison Legal News website that shows all in each state shows the number of lawsuits that they filed, and it's dozens and dozens of lawsuits, First Amendment lawsuits that have been filed on behalf of Prison Legal News because, as I think people know, prison and jail administrators have done a lot of things to limit the information that people get in, and so Prison Legal News is sued about that, but also they've done a lot to keep Prison Legal News itself out of jails and prisons, and Prison Legal News has sued repeatedly to get back in there. The other thing about Paul is that he was a great jailhouse lawyer while he was in prison, and I worked with him a lot on those things. And he's also been an incredible advocate, not just running Prison Legal News and many other things, but been an incredible advocate for prisoners since he's been out. And I wanted to give just a couple of quick examples. One example was when I was working in the Institutions Project, I think of Evergreen Legal Services at that time. Paul, on behalf of Latino prisoners in the state of Washington, got the prisoners to file on their own behalf, although I know that they didn't write the complaint, on behalf of monolingual Spanish-speaking prisoners, file a lawsuit saying we don't have access to information which allows us to have a fair shot in prison. We don't know what the rules are, we don't know what's happening to us at hearings because there's no translation. Paul caused that to be filed. He got in touch with us and said, what do you think? We took over the case and we didn't have to litigate it all the way because the Department of Corrections agreed and changed many of its practices, translated many manuals and rules, had translators at hearings, and all because Paul took the trouble to write this complaint on behalf of these Latino prisoners. More recently, Paul has been one of the spearheads of the phone justice movement that has recently been incredibly successful. Paul's family members many years ago now filed a complaint with the Federal Communications Commission to get rid of some of the exorbitant prison phone rates. I don't know if people know about this, but briefly, what happens is there's a sweetheart deal between the prison systems and the phone companies where they charge exorbitant rates for collect calls to families and friends. There are kickbacks, there's no other word for it, to the prison systems, and the phone companies and the prison systems profit from the people, most of whom don't have a lot of money who need to talk to their families. Paul has been one of at the forefront of this, and recently, just in October, the FCC has passed a rule that capping charges, not only interstate charges between states, but has taken the extraordinary step of capping prison phone charges locally and intrastate. It's really a remarkable change over what's happened, and really Paul has had so much to do with that. There are many, many other things I could say about Paul. He's an amazing advocate and a leader in the prison reform movement, but I will leave the rest to him. I just do want to say it's a great honor for me to introduce my colleague and friend, Paul Wright.
And thank you very much. First, I'd like to thank all of you for braving the cold and rain here of Seattle to come out and see us. I'd also like to thank our sponsors for sponsoring the event and making it possible, and both the two Johns for coming out as well. One of the things, listening to John, and I have heard him speak about prisons before, was in a lot of respects hearing a lot of the same things that what motivated him to start writing about prisons, also a lot of what motivated me to start Prison Meeting News. And I went to prison in 1987. I've been a military policeman before I went to prison. And I thought I knew a little bit about prison, but like most Americans, what I knew about prisons was watching movies, and I think the big one at the time was the Clint Eastwood movie where he escaped from Alcatraz. I thought that was my, the cornerstone of my prison knowledge at the time. And a lot of what really surprised me about what I found in prison was both the brutality and the dehumanization of prisoners. And having been in the military, I was kind of used to brutality and dehumanization. In some respects, it's kind of a seamless transition going from one to another. But what really surprised me was the lack of rules, or the lack of the rule of law. And I thought, okay, I committed a crime, I was adjudicated guilty of it, and I was in prison punishment for not following the rules. So I'm kind of thinking, well, maybe the people that are keeping me here should also have to follow the rules too. And that was one of the things that I found was very much lacking. And one of the things I've since discovered is that, first off, only the weak like the rule of law. And as a friend of mine says, well, there's a reason they're called pleadings. and that's been very much the case. So one of the things I thought is like John, I thought, well, most people don't know what's going on in prisons or jails in this country. If they knew, they would demand change. And I thought that 25 years ago. I still think that today. And so we started Prison Legal News in 1990. And we had, the big budget was $300, and that was enough. The budget for getting each issue out was around $50. And we figured, okay, we've got $300, this will help us publish 6 issues. And the goal was, we'll keep publishing the magazine as long as the money is there to keep doing it. And we had a mailing list. We cobbled together a mailing list of 75 people that we thought would be interested in subscribing. And John Mitchell was one of the first ones. I think some of you have been around for a while. I remember Pat Arthur. She was also the Institutions Project at the time. Fred Diamondstone, another, I think the kind of stalwarts of the Seattle civil rights community at the time. And so we published our first issue. We sent it out, and next thing we knew, the subscription back then was $10 for prisoners and non-prisoners, and $25 for attorneys. And I remember, I think John was one of the first people to, we got our $25 check from the Institutions Project. It's like, wow, we're just paying half our monthly budget. And, we're on a roll now. And basically, it hasn't really stopped. And we were an all-volunteer organization from 1990 to 1996. We hired our first staff person. And a lot of that evolution was, we're probably based in community volunteers here in Seattle. Our first 3 years, each issue was, I know some of you are long-time subscribers who remember that we were originally photocopied until 1993 when we switched to offset printing. We were photocopied. And then we've had a lot of volunteers a long time. At one point, one of our volunteers who worked at the UW and he had access to people's photocopying machines. So that really slashed our printing bill because he was able to print 200 copies of Prison Legal News every month on UW's copying machine. We were pretty happy about it. But as we kept growing, it was one of those things that when we started Prison Legal News, our goal was to have a voice here in Washington and give prisoners and our families a voice because we thought we're past the criminal justice debate in this country and in general and in Washington in particular. Everyone's being heard, everyone's talking, except for the people that are most impacted about it, which is the prisoners and our families. We're hearing about We're hearing from prosecutors, we're hearing from politicians, we're hearing from crime victims, we're hearing from just Joe Blow on the street. Everyone's got an opinion, everyone's been heard, except for those most impacted by it. And so I thought, if we started reporting on what's going on here in Washington, we could start having an impact, and hopefully a positive one. And this is in the context that to also put things into perspective, at the time we started publishing prison legal news here in Washington, there was about 50 or 60 different independent prisoner rights publications around the country. California alone had 6 or 7 at the time. A lot of states had theirs. Washington didn't have one at the time. So okay, we're going to start going out there and focus on what's going on here in Washington. And one of the issues that we confronted from day one was the issue of censorship. And I think H.L. Mencken is one that famously said that freedom of the press belongs to those who own one. Well, that's only half the story. The other half of the story, freedom of the press belongs to whoever owns one, but also who controls the means of distribution. And that was one of the things when the first issue of Prison Legal News arrived in Washington prisons, we were banned as being a threat to prison security. And okay, so we filed an appeal. The second issue arrived and in Washington prisons, and that was banned as well. And we prepared a lawsuit. We were trial pro se, challenging the censorship. And at that time, just as we're getting ready to file, the third issue arrived, that was censored. Just as we're getting ready to file, the DOC reversed course. And it said, well, we reviewed it, decided it's okay. So for now, and at the time, a guy named James Block, he was the warden of Washington State Penitentiary. And he sent me a letter saying that my ideas were outmoded and too radical and would find no currency or support among the new generation of inmates, and that he predicted we would not last 6 months. So anyways, that was in 1990. So I think that was around, I don't know, the July issue or the August issue. And on our 10th anniversary in 2000, I was still in prison, and I sent Jim a letter saying, by the way, here's a letter you sent me. You said we wouldn't last 6 issues. Here we are 120 issues later. You can see that he was wrong on that. So, so a funny thing happened along the way is that while PLN was focused here on Washington and the rest of the country, when we started publishing, there was 1 million prisoners locked up in the United States. By 2000, there was 2 million. And to put this into context, it took the United States from 1776 until 1990 to reach 1 million prisoners. It took us 10 years to double that number. And along the way, what we had as a vibrant prison press and prisoner rights media and means of communication basically started falling by the wayside. When we started in 1990, there was about 50 publications. By the mid-90s, that number had dwindled to 3 or 4. So by 2000, there's pretty much none left. And the role of prison legal news started changing. It started out as we focused on what was going on here in Washington State. And one day I'm in my cell, we wanted to look at our mailing list. And at this point, I think by the mid-90s, I think we had over 1,000 subscribers. And I think, gosh, somewhere along the way, we no longer have, Washington is no longer our #1 state for subscribers. We have more subscribers in California than we do in Washington. It's like, those darn Californians are upstaging Washington again. And then I started looking and like, wow, we've got more subscribers in Illinois than we do in Washington. And our news focus started changing too. As we get more and more subscribers, we were able to grow the magazine. So we started out at 10 pages. Then went to 16. We went to 20, 24, 28, 32. We're 72 pages now, 25 years later. And part of the thing is that there's not a lack of news to report. If we had the funds, we could easily publish a 100-page issue every month. There's that much going on. A lot of our coverage is just on the website. For example, our coverage of employee litigation, crime victim litigation, juvenile prison, stuff like that, that just goes straight to our website because we view the print magazine as kind of premium real estate, and we save that for prisoners who can't go online, at least not easily or legally, and to look at the website. But while we resolved our censorship issues in Washington, at least initially for our first 3 issues, Our first 18 issues were censored in Texas. We eventually resolved that. And then starting around the mid-1990s, we started seeing a lot more censorship. I think it's one of the things to put this into context. When I first came to prison in 1987, the Washington DOC's mail policy was around 5 pages long. These days, it's around 30 or 40. It's massively grown. We've seen there's been a massive clampdown on information, but it's not just in prison, it's also outside of prison as well, where we've seen restrictions and constraints on the information that people in and out of prison can get. And starting in the mid-90s, the Washington DOC did got pretty aggressive trying to censor prison legal news in particular. We've been banned by prison systems on everything from the basis of the prisoners paid for us from their prison trust account to the postage rate we use, whether or not we're being sent by bulk mail or standard rate mail as it's now called, to the fact that we're printed on newsprint. So we've had to challenge these, and it's been really, I think, one of the tributes to, I think, the legal community here in Seattle, that we've been able to not just publish, but the most critical thing is reach our audience. Because one of the things is, it's really kind of pointless to publish a prisoner rights publication with a target audience of prisoners on the one hand, as well as the overall public and outside public, to educate them on what's going on in prison, so you can't reach half of your target audience. And I think that's one of the things is that John alluded to the fact that prison staff often don't want to find themselves in prison legal news, but that's also a thing too of we're generally, the action of the news business is no one reports the good news. And we actually think it's kind of like one of those things, we don't need to pat anyone on the back saying, hey, you didn't kill anyone or you didn't beat anyone to death today, but when those abuses do happen, that is newsworthy, that is what we need to report. And the goal is to raise awareness so that change happens so that it doesn't continue to occur. And one of my favorites is, sometimes you call prisons or jails and ask for a comment or ask for some information, and who are you with? Prison legal news. And then it's like, you hear click, 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 as they go onto their computer and, oh, and you're Paul Wright? Yes, sir, I am. Click. Okay. So, and we get that a lot. But, so not surprisingly, the people that have control over the access like to censor us. As we stand here today, I think we've got 9 states under consent decrees or injunctions. Over 30 jails in 33 states are also under consent decrees or injunctions regarding the delivery of prison legal news, books we distribute, but generally what we've done with all of our litigation is strike down these broad rules that censor a lot of mail, not just ours, but those from all publishers and generally from the outside public as well. And we've also done a lot of advocacy over the years, especially a lot of our stuff has been concentrated here in Washington. John actually mentioned Lopez versus Ripple, that's actually one of the cases I'm fondest of. And I think it also illustrates kind of some of the problems that people in prison have in getting access to the courts. And I filed that case. I started out with 8 Hispanic prisoners who couldn't read or write English. They had an average of 6th grade education. And I thought, okay, if this is a case that I can't get counsel appointed on, there wasn't going to be one. So I got 8 affidavits from my plaintiffs saying we can't read or write English, we go to the law library, we can't do anything. So I filed a motion for appointment of counsel, and Magistrate Wilson, who some of you may remember, he gets it, and he says, oh, your pleadings are fine. You did a great job on the pleading, guys. Keep at it, and you'll just do fine. Which then the DOC started transferring the plaintiff, sounds like, into the system, and fortunately, Columbia Legal Services intervened to resolve the case. But some of the stuff too is for some people that have been around for a while. Remember back in the late 90s, Washington DOC tried to eliminate law libraries from prisons here in Washington. We successfully mounted a campaign with that. And I still remember one of the highlights of that was Jerry Alexander was the Chief Justice of the Washington Supreme Court at the time. And I wrote to him in his capacity as Chief Justice and said, if law libraries are eliminated, state court judges are really going to have a really hard time deciphering even more pro se prisoners. And this apparently struck a chord with him because he went to the legislature as did Justice Sanders at the time to testify against this, and the DSU backed down. We still have law libraries here in Washington. There's also efforts, going back in our little time machine, and for those who remember back in '94 when the Republicans swept the legislature here and seized control of both houses of the legislature, and they introduced legislation that would eliminate family visits, which I think is one of the best programs that Washington has. We were able to stop that, and so I think we've had a lot of advocacy over the years, and I'm very proud to say that we've played a leading role in that in terms of forming coalitions, being able to successfully defeat, I think, some of the most reactionary of these efforts. And along the way, HRDC, basically, we started out as Prison Legal News. We changed our name in 2009. And part of the reason we changed our name was because the organization had grown. When we started out, we were publishing a magazine, which actually started out as a newsletter. And by 2009, we had expanded to doing book distribution. We published, I've co-edited 3 anthologies on mass incarceration, the selling of American Insight, look at the U.S. prison industry, Prison Nation, the warehousing of America's poor, and prison profiteers, who profits from mass incarceration. And so that kind of got us going on book distribution. And our focus is all spent on self-help books, because the reality is with America's prison population, the problems are vast, the need is enormous, and frankly, no cavalry is coming to save the vast majority of people in America's prisons and jails. And we decided to start publishing or distributing these books, everything from the Prisoner Self-Help Litigation Manual to basics like English dictionaries to how to write a business letter. And we found along the way that this really rubs a lot of prison officials the wrong way. And then we got into book publishing, and we started publishing books, everything on how to get an education in prison, to habeas corpus manuals on ineffective assistance of counsel, to prison disciplinary litigation and such. And in 2009, we started a litigation project as well, where we were able to hire our first staff attorney to start being able to do litigation. And when we started Prison Legal News in 1990, one of our goals was to eventually be able to do public interest litigation. And it took 19 years, but we got there. And Lance Weber, our general counsel and litigation director, he's here as well. And part of what this has enabled us to do is challenge more of these unconstitutional rules and policies around the country that impact the right of prisoners to communicate and the right of people on the outside to communicate with them. One of the other mainstays of our litigation has also been public records litigation. And for anyone that's dealt with prisons, transparency is a huge issue. And I'd say public prisons, both public and private, are our least transparent of institutions. All things being equal, we probably know more about what the CIA is doing than we know about what's happening in the jails down the street from our office to prisons that are operating in our states. And to an extent, the media is also responsible for this. The New York Times at any given time has 6 or 10 reporters that cover the CIA, and they do not have a single reporter that covers criminal justice issues as a beat, much less what's going on in New York State or whatever. And we've made some landmark cases, and here in Washington, for example, Prison Legal News versus Washington, D.C., we were represented by Davis, Wright, and Tremaine. In that case, I filed a public records request in 2000 asking who were the doctors that have been disciplined for medical neglect or killing remaining prisoners in their care. And eventually the DOC had the pod, and they produced 2,000 pages of heavily redacted records. They didn't want to give you the names of who the doctors were. And we filed suit, and the defense of the trial court was, well, our legal obligation is to provide medical treatment to prisoners, and if prisoners learn from Prison Legal News who the doctors are that might kill them because they've killed or maimed other prisoners in their care, they're not going to want to seek medical care from these doctors, which you might say, well, that might be fair enough. And Sadly, the trial judge in that case, Judge McPhee, he bought that argument. And even sadder was the 3 judges in the State Court of Appeals bought that argument too. And fortunately, we went to the State Supreme Court and we won 6-3. And the court ruled that we were entitled to information that because the allegations of wrongdoing had in fact been substantiated because, well, they had in fact killed and maimed the prisoners in their care. We're entitled to that information. And the legal battle in that case only took 7 years, so 2000 to 2007. And at the time, it was the biggest award in a public records case. I think it was $542,000 at the time, which that was the biggest one at the time. And I think it's since been surpassed by 2 or 3 other cases. I think we're now like number 3 or 4. But one of the things that was really good about that is I can file a public records request with the Washington DOC these days and it actually gets answered. And the only things that just took 3 lawsuits, there was 2 lawsuits before that, before we got to this point. But now they're actually fairly good about complying with our state public records law, at least when there's a legal use sends a request to them. Some of the other cases we have going, like the Deer's Right to Remain also represents a sign includes we've got a long-running case with Bureau of Prisons that involves a FOIA request I filed in 2003 to find out how much money they spend in litigation to settle claims against them. And here we are going on 13 years later, and we're still arguing like the last 100 records. So, so some of the things that, like I say, is that it's been really critical over the years. The lawyers that have ensured the prisoners can receive our publication, as well as the lawyers that have ensured that we can get the information to continue our news coverage about what's going on. And some of the stuff that's happened is with the media as well. We've seen the demise of investigative reporting in a lot of the daily newspapers that used to do this stuff, a lot of the magazines, and it kind of makes the need for this type of transparency even greater now than it was in the past. So a lot of the landmark cases that we've brought over the years includes Allen PLN versus Washington DOC, PLN versus Columbia County. Jesse Wing and Katie Chamberlain are here today. At McDonald Hogan Bayless, they represent us. This was the first case where a court ruled that a postcard-only policy where a jail banned all means of communication except for postcards was unconstitutional. And we've since gone on to strike down on 5 or 6 more of these around the country. And I think that probably the tide is turning on the postcard policies. That I think, for better or for worse, we've eradicated all of them from the 9th Circuit, except for Sheriff Joe Arpaio in Phoenix, but he won't censor our mail. So, which I don't know how smart or how good or bad that is, but he's not censoring our mail, so we don't have standing to sue him at the moment. So. And I think one of the things that even though we moved our new office in Florida, we have an office here in Seattle, and Washington's always really been kind of home base for us. And I think as I look around Washington, you know, a lot of our supporters just earlier today, I was talking to Bob Combo from Graham Dunn and Joe Brinkman from Perkins Coie. We're going back about how long have we known each other and how long have they represented PLN and HRDC on things. And it's like, wow, we're going back about 20 years or so, which not to date ourselves, but you know, there's definitely long ties and long connections that we've had here in Washington, and that we're committed to maintaining. We've grown steadily from starting out with being an all-volunteer organization, and when our first staff person in 1996, we now have 13 staff, and we now have 13 staff in our main office in Florida, our office here in Seattle, and an office in Tennessee. And I think that one of the things that we're seeing is that's really different in the first 25 years of our existence, or at least the first 22 or 23 years of our existence. Pretty much all the news was fairly bad in terms of prison reform and criminal justice reform. Any talk that came about reforming criminal justice or prisons was very, very bad news. It was repealing habeas corpus, it was enacting the Prison Litigation Reform Act, and things like that. And in the last couple of years, in the last year or so, we're actually seeing a change in the public discourse on what's happening in prisons or jails. We've actually, for the first time in American history, a sitting president has visited a federal prison. of course, going back to John's comments about, torture and everything else, perhaps you shouldn't be leaving, but, that's another story. But the thing is that we're actually seeing some discussion about changing things as far as mass incarceration goes. Whether or not anything comes of it, we shall see. But one of the critical components that's missing about this newfound discussion on criminal justice reform that we want to try to change is, even if the United States reduces its level of incarceration where it was in 1990, for example, if they reduced our prison population by 1.5 million people, we're just going to be back at where we were in 1990, which was a huge departure already from the historic norms of American incarceration. Even with 1 million people in prison, that's still, even if we had 1 million people in prison and jail, that's 3 times more people locked up than China has, just to put things into kind of a numerical perspective. But the big thing is no one is talking about the conditions of confinement of people in prison. No one's talking about the right to be free from being sexually assaulted, the right to be free from being brutalized, the right to have adequate medical care and adequate medical treatment. And these are the things that I think we need to interject into the discussion, and that one of our goals is to push this. I was just at a Ninth Circuit Corrections Summit, as were some of the people that are here last week, and I think it's kind of interesting that we now see federal judges recognizing the need for prison reform. And I think this is pretty significant since they've kind of contributed to it. I mean, every person in prison was sent there by a judge. They didn't just like magically appear in prison all of a sudden. They were sent there by a judge, usually with a very long sentence. So there definitely seems to be a lot more interest and discussion in the issue, and I think we need to propel this along a lot farther. Whatever change is being proposed, the change needs to be bigger, deeper, and go farther than is being proposed. One of the things I'd like to say in closing is, I think I've been the public face of the organization for a long time, but also in prison since I've been out. But one of the critical things is it's never been a solitary endeavor. It's never been, it's just Paul Wright or it's just the Paul Wright show. And everything that has been accomplished has been very much a group effort. And it's been everything from the people that have written for us, which I think at last count we've had hundreds of people write articles for Prison Legal News. Some of our contributing writers have marked more than 1,000 articles published in print in Prison Legal News over the years. Certainly the lawyers that have represented us over the years, which our magazine, our 25th anniversary issue, we ran down and believing going back almost 25 years to track down every lawyer that's represented us over the years was quite the endeavor. We've got literally dozens of lawyers that have done this, and I think that one of the things is that sometimes I think with lawyers it's hard to measure the impact that you have on the lives of others. And I've looked at the censorship cases that PLN has won over the years, and we've only lost around 4 or 5 cases out of dozens, that's a pretty good track record. And I can say is that one of the things that, but for the litigation efforts by the lawyers that represented us, around 800,000 or 900,000 prisoners would not be getting the stuff in the mail that they're getting today. And when you talk about impact litigation, when Jesse Wing and Katie Chamberlain represented us in the Columbia County case in Oregon, 33 county jails in Oregon banned all mail except for postcards. And by the time we wrapped up that case, and we're kind of figuring, wow, we got like 32 more to sue after this one. By the time we wrapped up that case, and Judge Simon ruled in our favor, that all the other jails had dropped their policies. They'd all changed it and reverted back to more constitutional policies of allowing letter mail again. But apparently, the insurance carrier told them, hey, we're not going to pay out any more money for this nonsense. And we had the same thing in South Carolina. We sued a South Carolina jail that banned all books and magazines except for the Bible. And which I'm not really sure which one is more upsetting about that, because it's like, well, they're banning all books, including the Bible. That's kind of offensive. But then when they ban everything but the Bible, well, it seems a little biased as well. And when we filed suit there, every single jail, I think it's 31 counties in South Carolina, every single one of them banned all books and magazines. And they put up quite the score to the defense. The Department of Justice, for the first time, and so far the only time, intervened on our behalf because they were concerned about the Establishment Clause issues. And by the time we wrapped the case up, every single jail in the state had dropped their ban on books and magazines, and they now allowed books and magazines to enter the jails in that state. So it's one of the things where it's really hard to measure the impact in some respects, where you think, okay, we actually got a consent decree against this one jail, but then on the other hand, we didn't have to sue the other 32 or the other 31 or however many there were. And I think that's one of the things, especially in institutional reform litigation, these are, that type of impact and that type of victory is rare. And I'm certainly proud that we've been able to do that, and I'm also very grateful to all the lawyers that have represented us on these cases that have made this possible. Our staff over the years, we've had plenty of, we've had a lot of people that have worked for Prison Legal News over the years that have made this possible, and that continue to make our work possible. And like I say, just because I'm a guy that people see out there doesn't mean that there are a lot more people working for us. Sam Rutherford is here. He worked for us for a number of years here in Washington. Mary Wilkinson, she's here. Susan Schwarzkopf has been our advertising director since 2007. And when Susan started working for us, you can thank Susan for the growth of the magazine. When she started working for us in 2007, we hired her as our advertising director. And I think at the time our page count was around 36 pages at the time, and we got a grant to hire her. And I told her, well, we'll hire you, but you need to bring in as much money in advertising you've got to fund the growth of the magazine and cover your salary. And anyways, in 8 years, we've gone from, I think it was 32 or 36 pages to 72 pages. And that growth in editorial content has been basically thanks to our advertisers that have been able to fund our growth and increase it. And in the 5 years that Lance Weber has been our general counsel and our litigation director, we've basically been able to really increase the amount of work that we're able to do on the litigation front. I was being deposed in Oregon a couple of years ago. In fact, I think it was in the Columbia County case. And I'm being asked, well, from 2000 until 2010, Prison Legal News filed roughly 1 lawsuit a year. Then in 2010, you filed 10. What happened, Mr. Wright? Well, we hired a lawyer. So what did you think was going to happen? And I think that's been one of the things that we've been able to increase the impact that we have, as well as the reach of our litigation. And I think bringing a little bit more information, a little bit more knowledge about what's going on there. And the big thing is, our biggest supporters too, that we wouldn't be able to do it without, have been our subscribers and our advertisers and our other supporters. And we've had a lot of those over the years. And I think after around our 4th or 5th anniversary issue, we got to the point we can't name everyone just because, well, there's so many of them. So again, I'd like to thank all of you. I'd like to thank, again, all of you for attending. I'd like to thank our event sponsors for making it possible. And if any of you would like to make a donation to help support our work, which sadly much remains to be done, we're happy to take any donations. And for those who are not familiar with recent copies of Prison Legal News, we have some recent copies out there. So thank you very much for attending. I'm glad you